Key cases: Marbury v. Madison, 1803. In 1801, President John Adams was leaving office. Before he left, he appointed William Marbury and others to government positions as federal judges, called midnight appointments because they were made at the very last minute. These appointments needed official papers called commissions to be delivered. When Thomas Jefferson became president, his Secretary of State James Madison refused to deliver Marbury's commission. Marbury sued Madison, asking the Supreme Court to force Madison to deliver the papers. Marbury based his claim on the Judiciary Act of 1789, which said the Supreme Court could issue such an order, termed a writ of mandamus. This specific provision in the Judiciary Act of 1789, Section 13, the Supreme Court shall have power to issue writs of mandamus to persons holding office under the authority of the United States. This seemed to give the Supreme Court original jurisdiction, the power to hear a case first, to issue writs of mandamus, orders that compel government officials to do their legal duties, like Madison delivering Marbury's commission. The U.S. Constitution, Article 3, Section 2, clearly limits the types of cases the Supreme Court can hear under original jurisdiction, those that start in the Supreme Court. According to the Constitution, the Supreme Court has original jurisdiction only in cases involving ambassadors, public ministers, and consuls, and cases where a state is a party. All other cases must come to the Supreme Court through appellate jurisdiction, after being heard in lower courts first. Marbury's case didn't fall into any of those original categories. It was just a request to force a government official to act. Nor did Marbury exhaust his remedies in the lower courts so that it could be properly brought before the Supreme Court. Marbury v. Madison was the first time the Supreme Court said a law made by Congress was unconstitutional. The Supreme Court, in its decision, determined itself to have the power of judicial review, the authority to decide whether laws follow the Constitution. Before this case, it wasn't clear if the court could cancel laws that went against the Constitution. This new power made the Supreme Court equal in power to Congress and the President. It turned the Constitution into the ultimate rulebook, not just a guideline. It defined the court's role as the guardian of the Constitution. Brown v. Board of Education, 1954, the Supreme Court addressed the constitutionality of racial segregation in public schools, fundamentally questioning whether such segregation violated the Equal Protection Clause of the 14th Amendment. Post-Civil War America saw the introduction of the 14th Amendment in 1868, aimed at ensuring equal protection under the law for all citizens. However, the 1896 Supreme Court decision in Plessy v. Ferguson upheld the constitutionality of racial segregation under the separate but equal doctrine. This precedent legitimized segregation across various public facilities, including schools, leading to widespread educational disparities between black and white students. The central jurisdictional question in Brown was whether the Supreme Court had the authority to overturn state laws that mandated racial segregation in public schools. The plaintiffs argued that such state laws infringed upon the Equal Protection Clause of the 14th Amendment, thus falling within the court's purview to review and invalidate unconstitutional state actions. The plaintiffs contended that segregated schools were inherently unequal, causing psychological harm to black children and depriving them of equal educational opportunities. Thurgood Marshall represented plaintiffs' argument asserting, they have equal rating, equal footing, and if segregation thus necessarily imports inequality, it makes no great difference whether we say that the Negro is wrong because he is segregated, or that he is wrong because he received unequal treatment. The defense led by John W. Davis maintained that the separate but equal doctrine established in Plessy v. Ferguson provided a constitutional basis for segregation, arguing that segregated schools could offer equal educational opportunities and that education policies should be determined at the state level without federal intervention. He insisted the issue was one of states' rights and that there was no constitutional mandate requiring integration. He also emphasized that local customs and legislative decisions should not be overturned by federal courts unless there was a clear constitutional violation, which he denied existed in this case. Chief Justice Earl Warren delivered the unanimous opinion, stating that racial segregation in public education violated the Equal Protection Clause of the 14th Amendment. The court recognized that segregated schools, even if equal in tangible factors, imposed a sense of inferiority among black children that adversely affected their educational and personal development. Warren wrote, "We conclude that, in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. By asserting its jurisdiction to review and nullify state laws that violated constitutional rights, the Supreme Court reinforced the principle that state-mandated segregation was incompatible with the constitutional guarantee of equal protection under the law." Key determining factors in deciding the case stemmed from Drs. Kenneth and Mamie Clark, two Afro-American psychologists who before the court administered their doll test. The test was simple, requiring two dolls identical in nature other than one being white and the other being black. These dolls were administered to children, while the doctors asked the children which doll is nice. Which doll is bad? Which doll looks like you? Many of the Afro-American children associated the positive qualities with the white doll and the negative traits with the black doll. To the court, this demonstrated that segregation instilled a sense of inferiority in Afro-American children that affected their self-esteem and educational development. Chief Justice Warren referenced this evidence directly in the opinion. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. Roe v. Wade, 1973, and Dobbs v. Jackson, 2022. Abortion rights, reversals, and deep philosophical divides. The U.S. Supreme Court addressed the constitutionality of Texas laws that criminalized most abortions, fundamentally questioning whether such statutes violated a woman's constitutional rights. Prior to 1973, abortion laws varied significantly across the United States, with many states imposing strict prohibitions except in cases where the mother's life was at risk. These restrictive laws led to unsafe, illegal abortions and heightened public debate over reproductive rights. The 14th Amendment, ratified in 1868, includes the Due Process Clause, which prohibits states from depriving any person of life, liberty, or property without due process of law. This clause became central to arguments about personal liberties, including the right to privacy. The Supreme Court needed to determine whether it had the authority to adjudicate a case involving state abortion laws and if such laws infringed upon rights protected by the U.S. Constitution. Represented by attorneys Sarah Weddington and Linda Coffey, the plaintiff challenged the Texas statutes on the grounds that they were unconstitutionally vague and infringed upon her right to personal privacy. The plaintiff's team argued that this right to privacy was protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. The defense, led by Henry Wade, the district attorney of Dallas County, maintained that the state had a compelling interest in protecting prenatal life. They argued that the fetus should be considered a person under the 14th Amendment, thereby warranting state protection. The defense contended that the state's interest in safeguarding potential life justified the regulation of abortion. In a 7-2 decision authored by Justice Harry A. Blackmun, the court held that the Due Process Clause of the 14th Amendment encompasses a right to privacy that protects a woman's decision to terminate her pregnancy. We, therefore, conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests in regulation. However, this right is not absolute and must be balanced against the state's interests in regulating abortions. The Roe v. Wade decision established a constitutional right to privacy, safeguarding individual liberties against state encroachments. These cases share a common theme in the Article III courts and its lower inferior courts, established by the United States Constitution. These themes are constitutional review, is the law constitutional, and the power to strike down unconstitutional laws that violate the express or implied powers outlining the authority of states and government, while also protecting the rights of the citizens enumerated but not expressly exhausted therein. We will dive into more Supreme Court cases later in the series that have defined, shaped, and upheld the constitutional foundations of sovereignty within the United States of America, upholding both the rights of the state and the individual.